What's up, everybody? It's the lawyer coming at you from an undisclosed location on our family vacation up in the mountains, but we've got a lot to talk about. So we decided to take some time tonight after we put the kids to bed and talk about some of these cases and talk about whether we think verdicts are coming soon, if at all, in some of these cases. And we're going to touch on Alec Baldwin a little bit at the end. But first, we're going to talk about the Ghislaine Maxwell case and then the Elizabeth Holmes case, because a lot is actually happening, a lot more than I expected. And as always, I'll just kind of give some tidbits about what I've found, what I think is interesting, and break them down from a lawyer's perspective. And then we'll get to your questions, which is always the fun part of the video. So make sure you get your questions. For any of you who are new to our channel, my name is Peter Tragos. I am a personal injury and criminal defense lawyer in the Tampa Bay area in Florida. And we started our YouTube channel a little over a year ago. And we're hoping actually today during this live to get to 25,000 subscribers. We started about a year ago. And we break down some videos, talk about some cases, give you a real life trial lawyer's perspective, because this is what we do. So when we're waiting on verdicts, we can talk about this because we've waited on a lot of verdicts in our firm and in our time. We have tried these cases. We've done the opening statements. We've cross-examined witnesses. We've gone through the litigation process. So we know what comes in, what doesn't, how we get this evidence, how to build a case, how to deal with law enforcement federally, FBI agents, and local police. And then we've handled catastrophic injury cases, wrongful death cases. So we just can bring a lot of insight. And I think the people that follow this channel find that interesting. And we also like to answer questions that people have, because we have a lot of people in our life that ask us questions because they know us as lawyers. And now we want to be lawyers that so you can ask us questions as well. So that is basically a breakdown of who we are and why we do this. And before I get to it, okay, so I'll answer a couple questions here since we're just off the jump. And Pedro, why are some trials televised and others not? Depends on the judge, depends on the courtroom, depends on the state. But most of these trials, especially the two we're talking about today, are federal trials. Federal trials, no cameras are allowed in the courtrooms, no cell phones unless you get it approved by the judge, no iPads, no technology unless you get it approved by the judge. So there are no televised federal trials in the United States. No, this is not my bedroom. I'm sure I'm going to be getting a lot of questions about where I'm at and what it all looks like. This is one of the kids' bedrooms here in the place that I'm staying. So let's get into just a couple things that I've found interesting that have happened over the last few days since we talked last at the last live that we did. And first, we'll start with the Maxwell trial. So a huge point of contention in this Maxwell trial has been when they're going to testify. When they're going to deliberate, how long they're going to deliberate, if they're going to take certain days off. They've been given a day off, I believe, for the holidays, even before the federal holidays. The judge said, no more of that. No more days off. And she's pleading with them to stay late and work as long as they can to try to get to this verdict, because she is very worried about the corona outbreak that's hitting again. Numbers are spiking. She's worried that it's going to affect the verdict. This is really interesting because in every case, we determine how many alternate jurors we're going to have, because we think people just get sick and stuff pops up. A family member gets hurt, goes to the hospital. They can't come to the courthouse that day. Stuff happens in normal circumstances and normal scenarios where we as the trial lawyers are worried about that. When we pick alternate jurors, we assume they're going to be making the decision in our client's case. We don't pick alternate jurors as throwaway jurors. So I think that's important to note, that the lawyers know a lot about these jurors, even the alternate jurors. They know which ones are good. They know which ones are bad. They know if one gets called up to the big leagues, that it could be good or bad for them. So alternate jurors are really important in every case. But right now, the alternate jurors dealing with coronavirus and the spikes here. We've had tons of friends that it's affected their holiday trip. They haven't been able to go to work. They've traveled and seen family and come back, and now they have it. Because over the holidays, you're around a lot of people you're not around otherwise. They're coming from all over the place. You're breaking bread together. You're hugging, you're kissing, you're shaking hands. And, it's easy for the virus to spread. And so the judge is really worried about that. It seems like we have gotten through the holidays, at least Christmas, but now New Year's coming up. I think the judge really wants to have this verdict by New Year's, before the holiday. So she's trying to push them to work late. Usually the jurors make the rules by allowance of the judge, because obviously the judge is the king or queen of their courtroom. But I think it's really interesting how this judge seems to be pushing them more than some of the other judges in some of the other trials. All right. And so what has the jury, what insight has the jury given us on what they're thinking, which way they're leaning? Well, we had some notifications that they have asked for specific transcripts. The specific transcripts that they're after are the 2 victims and then the 2 other complaining witnesses or corroborating witnesses, or whatever you want to call them, the females that were abused by Epstein and Maxwell. Those are the transcripts they initially asked for. Then they asked for Juan Alessi, who was the employee there, one of the corroborating witnesses for one of the victims, and one of the local Palm Beach police crime scene investigators' transcripts. So a bunch of prosecution witness transcripts. What could they be looking for there? Who knows? Because you never really can enter the mind of a jury, especially when they ask for so many transcripts. Now, when we talk about Elizabeth Holmes, what they asked for is pretty interesting to me. But in this case, I don't really think I can learn a lot by what the jury's asking, because there's so many different transcripts that say so many different things. So not really an indication to me that they're leaning one way or the other, except I think they're leaning guilty, which is what I've kind of felt they were leaning the whole time. The next thing that's really interesting to me is they asked the judge for a definition, a legal definition of enticement. So in the comments, put in there what you think the legal definition of enticement is, or what it means to entice these girls to be abused by Jeffrey Epstein. What do you think in the comments? Let me know what you think enticement is. And I'll vamp here for a second before I give what the judge gave as the legal definition, so as to talk about another question that the jury had that the judge and the lawyers declined to answer, and they referred them back to the jury instructions. Now, what that could mean is that the jury asked for some information that was inadmissible, and either the lawyers objected or the judge didn't feel comfortable giving them that answer, or it asked for facts outside what happened in this trial, facts not in evidence, what we call them. So some other indicator that they can't actually give them because of the trial. But instead of just declining to answer the question, because they referred them back to the jury instruction, that to me indicates that it wasn't facts not in evidence. It wasn't something on the outside. It was something that they couldn't necessarily agree on how to give an answer to the jury, or at least one side felt that that was already answered in the jury instructions, and to give them an additional answer would be going outside the purview of the judge and be overstepping their reach, instead of just saying, we gave them jury instructions that we all agreed on, so let them go back and read those jury instructions. And if they can't get the answer from that, too bad. And it sounds stupid to say, and it sounds bad to say, that if they can't get the answer, they're too bad. But we say that a lot to juries, because there are certain things. The reason there are standard jury instructions, and the reason that there's certain verbiage and the way that you say certain things to a jury is has been litigated before. It's gone up through appeals. Higher courts have determined what the appropriate way to instruct the juries. It's not just like I sit down and I'm like, okay, I'm going to do this sex trafficking case and I'm going to make up the instruction I want to go to the jury. That's not really how it goes. We pick from a standard, and if we're going to edit some language, we'll edit some language. But there are standard jury instructions that have gone up, stood the test of time, basically, and that's kind of how we start. So anytime we go outside those jury instructions, we have to make sure we're doing it right. In this case, they declined to for one of the questions that the jury had in this Maxwell case, and they just sent them back to the jury instructions. Okay, so I've given you enough time to give what you think the definition of enticement is legally. And the judge, what he told this jury to decide Maxwell's fate is to attract, induce, or lure using hope or desire. I have a couple thoughts on this definition. First, I don't know why this definition wasn't already in the jury instructions, because sometimes how it'll look is it'll say, inducement to commit a crime, whatever it may be. It'll give the first paragraph. And any words in there that need a definition, usually, boom, the definition comes as A or some subparagraph that defines the words that may need to be defined in that paragraph. But there are times where we cut out those definitions as lawyers. When we're going through the standard instructions, we're having the charge conference, we're talking to the other side and talking to the judge what these need to be. We try to trim them down as much as possible just to have what's necessary. And so sometimes we cut those definitions. They may have done that in this case, which makes it really easy. If the jury asks for a definition, you take the definition you cut out, you give it to them, and it's really easy. I'm not sure if that's what happened in this case, or if there was no definition and they used the dictionary or some other way to come up with a definition of enticement. But to me, the interesting part of this, so to attract, induce, or lure, fine, that makes sense for enticement. Using hope or desire. That's interesting to me. Using hope or desire. Hope of a career, hope of money, desire of money, desire to get the connections of Epstein and Maxwell. That's kind of how I would read it. If I was the defense attorney, I would not have liked that ending of the definition. I would have just like attract, induce, or lure to do something you want them to do, basically. But to entice using hope or desire, to me, is pretty interesting that that's part of the definition. All right. So what I'm going to do now, I'm going to look in here to the chat. Let's answer some questions on Maxwell before we jump into Holmes. We'll try to separate this video as much as we can, but I'm sure questions will be coming throughout. So I'll get to them throughout. I'll just take a little pause here before we jump right into what's going on in Holmes to talk about Maxwell. Steve Shee, good question here. Does a hung jury change the thinking on Maxwell getting bail going forward? Is she likely to get bail if it's a hung jury? And this is one of the interesting questions when we talk about the coronavirus. We talk about maybe if it goes through the jury and we have to have a mistrial because we don't have enough jurors to make this decision. Nobody wants that. And why most people don't want a hung jury, but sometimes the defense will take a hung jury, is because that at least tells you something. If the jury gets COVID and it's a mistrial, we don't have enough jurors to make this decision. That tells us nothing. We have to do it all over again. A waste of time, money, and resources for everybody. But if we have a hung jury, at least I, as a criminal, and I've had this happen, I've gotten a hung jury before in a trial, and we have ended up getting a great deal offered by the prosecutor that we told our client we think she should accept, but it's up to her, and she ended up accepting it. It was a sweetheart deal because, in fairness to the prosecutor, we obviously convinced some jurors that there was a reasonable doubt, right? And if that's the case and you're seeking justice and seeking the truth, maybe that's a good time to come to some kind of plea agreement. So a hung jury is much more indicative that there is some doubt in this case than just a mistrial, obviously, because we don't know. And I think that it could affect bail going forward. Now, I don't know if it will because there are a lot of factors, but one of the factors of bail is how strong is the evidence against the defendant? How damning is that evidence? And I think a hung jury would prove maybe it's not as strong as we originally thought. Oh, come on, Brett. You can't be making up stuff like that. Hello from Brazil. Good day from New Zealand. How many days between verdict and sentencing? We'll just have to see when the sentencing hearing is. There's no like specific, it happens a week later. We'll see. Because a lot of times even the defense can ask for a continuance to put together witness statements and all sorts of stuff. The sentencing hearing can be like a mini trial on its own, especially in these federal cases. We just did the sentencing hearing for one of our cases, and it took hours and hours, took half a day in one of our federal cases that you guys may already know about if you've watched some of our other videos. Interesting. Anna S. doesn't think there's going to be a video in any of these cases. Ajay, Theranos and perhaps other trials too. Do longer deliberations mean it's more likely at least one juror is holding out? How often do jurors change their mind? So I have heard, and the research shows that jurors change their mind a lot actually through deliberations, and whatever the initial vote is not always how the ending vote happens. So some jurors change their stuff or have changed their vote. Annie, judge shouldn't be pressuring the jurors. They have enough stress to deal with. I agree, but I think there's nothing wrong with making them work later hours and come in every day to make sure they get this job done, because the delay doesn't really help anybody either. So if they are working towards a verdict, let's put in the work and let's get it done. All right, we've got some enticement definitions: to persuade, using some kind of lure, to tempt, give something to someone in exchange. Not a full definition there. To influence or pressure someone to make a decision, to give incentive in exchange for specific action, provoke, to lure, to tempt. Cat without likes my bunk bed. Thank you. It's not mine, but luring or tempting someone with money. So throwing in there the with money is important. Trying to lure or attract. Yeah, these are all good. Yeah, hope or desire seems sort of vague. I agree. But you can see how it may work in this case. All right. Okay, here's a good question. So, Jean Hood, is 4 days long for a jury deliberation? So, let's talk about this. Greetings from Argentina. All right, let's talk about this because there were some studies done and some research that I found, because we've done some white collar crime, which Theranos, and we're kind of transitioning into Theranos, and that would be considered a white collar crime, unlike the Maxwell case, obviously. So they've been going, I think, 5-ish days. They've been deliberating, and so people were asking, was this normal? How long does it usually take? And they did some research, I think, on the last 15 or 20 high profile white collar criminal trials, federal trials, and the jury took between 3 and 12 days. They surmise, based on the length of this trial, that it's going to be somewhere in the 10 to 12 day range to get a verdict. Now, I think there are some extenuating circumstances, right? Because in a lot of those other trials, there was no COVID. And a lot of those other trials, they were not over the holidays. Right through Thanksgiving, Christmas, New Year's, basically, this Theranos trial has been just running through the holiday season. I think that makes it a lot more difficult. And I think that is a cause for a delay that's going to make it kick to that higher end. So if you're wanting to know when it's going to get into kind of uncharted territory, if they're deliberating for more than 2 weeks, once it goes into day 15, 16, 17, now we're thinking, what is going on? So I expect the judge to push them a little in Holmes as well. We haven't heard about the same urgency or push by the Holmes judge as we have from the Maxwell judge, but I wouldn't be surprised if we saw that soon as well. So the Holmes jury is not giving us as much as the Maxwell jury. They're not giving us as many questions. They're not asking to see and focus on as many things, but it seems like they are focusing on the secret recordings of Holmes basically pitching her business plan to investors. And here's why I think that's important. I think that one of the biggest parts of this testimony, if you put all kind of the shenanigans and the smoke and mirrors aside, one of the biggest parts of the testimony that was contradictory is we heard from some investors and witnesses that Holmes made certain promises and said certain things specifically, that contracts were in place or the government was using it or whatever it may be. She dropped some big name private companies, right, that we've all heard of before. But when she took the stand, she made it seem more like she indicated that they were working towards partnerships with them, or they were working with the government on how to build these things, but not necessarily that they had these contracts signed, sealed, and delivered. So I think they're taking that contradiction, and the jury is listening to Holmes's own voice in these pitches to see what exactly did she say, what was her MO. And even if this was not the specific pitch that was testified about at trial, I think it can be a good indication of how Elizabeth Holmes pitched this idea, right? Did she make promises and guarantees? Did she pound the table? Or was she saying, listen, the future is bright. We've still got some kinks to work out, but we're supremely confident it's going to change everything. And that's why all these companies want to get in on it with us, and they're going to get in on it with us, or they've been in talks to get in on it with us, or whatever it may be. They were making certain indications of those promises, or was she actually saying it's a done deal? Here are the contracts we have. Read them in black and white. We have all these people in on this with us. You want to get in on it too. And I think the actual verbiage and language she uses in those secret recordings in her own low voice that could be a huge game changer, because if a jury thinks a criminal defendant is lying, they're cooked and they lose every time. It may seem obvious to you, but to me, somebody can be lying and also not guilty. I think that can happen. You can call me a criminal defense lawyer, drinking the Kool-Aid, but to me, just because they lie doesn't mean they're guilty of what they were charged with. But if they do, and that's why taking the stand is such a big deal, if they do take the stand and the jury thinks you're lying, usually you're done. And they're just going to be like, well, they're probably lying about everything. And so we can believe what everybody else said that's on the opposite side of them, and therefore we're going to convict them. So we'll see how that ends up coming down. So I think we could have verdicts in these cases by Thursday. I think at the very latest, we will have all the answers we've been waiting for the first week of January, whether it's a verdict or a hung jury in both of these cases. Hopefully we get verdicts. I think they're going to be both guilty verdicts, but no, I don't have a crystal ball. I'm just guessing based on the evidence that I've seen, the way it's seemed to have come off in the courtroom, and the 99+% conviction rate federal prosecutors have when they get to this point. No guarantees, but that's about as close as it comes. So let me know what questions you have on Holmes now, and we will answer as many of them as we can here. Brett, is there even a 1% chance there'll be a verdict for either case on a Sunday? No, federal court staffs don't work on Sunday. And that would have to be a very special thing that they do to bring in the staff on Sunday and the jury on Sunday to deliberate. Wow, I did not see that. Somebody said they just heard Mark Means was disqualified from Lori Vallow's case. Interesting. Sapphire, why don't you guys guess? What do you think it is? All right. Carrie Adams. Yep, there's a ton of testimony for both of these juries to consider. So Anna S., why are trials scheduled knowing there are holiday breaks, etc., that could slow down the process? So this is tough, right? We got delayed. Our field got, in case anybody doesn't know, in America, the courts are clogged. There are more cases than trial judges we have. We have multiple trials set every month next year. It's impossible to get these cases to go to trial for one reason or another. So when the opportunity presents itself and trials seem to go away during the holidays, we got to get these cases to trial. And when the opportunity presents, you got to take it. And these lawyers and these judges decided to take it, do the trial now, knowing the risk of the holidays. But it's better than, because you can't just kick this case to January 12th. You're going to kick it 6 months. They didn't want to kick it for lots of reasons. So I think that's important. That's important. So I just got a notification that we're at 24,999 subscribers. So if you haven't subscribed, go subscribe now. Take a second. Be the 25,000th subscriber to our channel. Also, if you're enjoying the commentary here and the content, hit the like on the video for us so we can keep rolling forward into the new year with 25,000 plus subscribers. It's crazy to me that we are here. I didn't know anything about YouTube when we started this, so that's just fun. Sorry for the... Oh, come on. Cat without the hat. You can't tell me you thought this was the Redskins, which is now the Washington football team. But we are still the Seminoles here. Come on, it's Florida State. All right, let's see. So Nadia Wren. How come the jury could not see the FBI's notes of Carolyn's first interview? I thought it was brought into evidence when she was being cross-examined. So I'm not positive exactly how each one of these steps took place in this case because I wasn't in the courtroom, obviously. But I can tell you, sometimes things like this happen where, and this is what I think happened while Carolyn was being directed and cross-examined, where she was impeached with the FBI notes, meaning, don't you remember when you talked to the FBI, you said this, that's different than what you say today, right? Why did you change your story? Things like that, right? Where they're impeached and they reference these FBI notes. They may even read them to the jury. They may read them to Carolyn. Carolyn may read them and say what they said. So they came into evidence like that, but usually notes like that would not be an exhibit that comes into evidence. You can use the old adage in law school is you can use a pizza box or a drink to impeach somebody, right? As long as it will refresh their recollection or let them know what they're saying is wrong, and you can impeach them and show the jury that they're wrong, you can use that to impeach. That does not mean it's evidence, and it definitely does not mean it can go back to the jury. Now, anything that came in as an exhibit, that can go back to the jury. Actually, it already has gone back to the jury, and the jury can look at it. But if something was used outside of the evidence to impeach a witness like Carolyn, it does not go back to the jury. The jury cannot read through the FBI notes. There's a million reasons for why those notes could be inadmissible. Thank you, Johnny Appleseed. The likes help attract new viewers. Didn't even know that. Cool. Brett's never had jury duty. Why does it take so long? There's a million reasons for this, right? Maybe they're going through every piece of evidence slowly. Maybe there's a gridlock. Half the room feels one way, or just one juror feels one way. It has to be unanimous in these cases. So that is another reason why. Or they are reading through the charges and they don't understand what the charges are. There's just a ton of reasons why it could be taking so long, but it seems like they're doing their job and they're trying to come to the right verdict. Also, the outside pressures on cases like this, they know the world is watching. Same thing with, the Rittenhouse case and other ones. There's a lot of ramifications for what your verdict is, so they're taking their time. Thank you, Annie. Yes, Mark Means was disqualified. I'm sure we'll be doing a video soon on that. So no, Ajay, I have not heard the recordings myself. I believe they are sealed and just the jury can hear them. It is not a Diet Coke. Mark Means definitely disqualified. Tally Cali, that's right. Go Knowles. Leave this one on the screen for a while. Correct, it is not the aforementioned Redskins, now Washington football team. So Thad, the man, said he would love to see Maxwell as a hung jury, force the prosecution maybe to open their hand a little more and open the black book, right? Don't worry about it, Cat, without the hat. I understand the mistake, and even the colors are similar. All right, every defendant, this is a good discussion to have. Every defendant should demand a speedy trial at the same time. That is next to impossible, because if you demand a speedy trial and the prosecution shows up for it, you have to do it. And if you're not ready for trial, you're screwed. And a lot of times defendants don't have all the discovery they need because prosecutor gets to delay and the judge doesn't force them into it. So I get the sentiment, and we have done it before, and it's really interesting when we do it. All the procedures change and prosecutors get pissed, but it's tough. All right, we got a super chat in here. Julia, would you explain when it is beneficial or dangerous for a defendant to testify? So we talked about this a little bit with the Rittenhouse case, and I think it's always important for a defendant to testify if the jury needs to know their state of mind. Were they in fear? The jury always wants to know why, right? So it's beneficial if you can give a good answer to why. Now, when can it be dangerous? If the defendant has some crimes in their past that have nothing to do with this case, but they're going to have to say, yes, I've been convicted of a felony in the past. Sometimes juries just say, once a felon, always a felon. If they've been convicted before, we should convict them now. They probably did this. So even if it has nothing to do with the case that they're being tried on that day, it can be really dangerous based on their past. Additionally, if you have some inconsistent statements or multiple interviews done, like Alec Baldwin, who we're going to talk about a little bit at the end of this video, if you say anything that's different than any other interview, they're going to impeach you and make you seem like a liar. Even if it's the smallest of detail, maybe has nothing to do with the actual facts of the case, they're going to make you look like a liar. That can also be dangerous. It really depends on how your defendant presents, how they deal with cross-examination, because average everyday people usually can get tripped up by a professional questioner, right? We are, as lawyers, we pick people apart in questioning. We ask them questions with specific reasons in mind, and we know what the answer is going to be and we know how to use that answer. So sometimes people just step in it, whether they, are trying to or not. And it can be really dangerous depending on how the witness is, depending on how the witness presents. And then lastly, if we don't think the prosecution has a very strong case and we don't think they proved their case, why give them anything else to work with? So if we feel really strongly about the case, people think that criminal defendants don't take the stand because they're scared or they have something to hide. A lot of times it's when we feel really strongly about the case and we don't think we need the defendant to take the stand because the prosecutor didn't hold their burden. 25K, we hit it. Purple Haze, maybe you were 25. Sometimes YouTube's behind on popping it up. Sometimes it scrubs them and it goes above and below 25. But awesome. Thank you guys so much. 25K. Just Tub. Oh, maybe it was Ian. Maybe it was Ian that was 25K. Awesome channel. Thank you. Jimmy, thank you. Yes, Carrie. Hit the like button. Just wait for, just push you over the line. Maybe it was VSync. Awesome. You guys are awesome. Appreciate all you guys. This was fun. Good morning from Bangkok. It's fun to just hit these little benchmarks, little things that make it fun. Could she go to jail? Yes. Either one of them would score prison, Maxwell or Holmes. Either one of them would score prison if they were convicted. Ajay, yes, civil suits theoretically would still be possible, but I don't know if that Epstein fund would release her civilly, even though she wasn't named by some of them. I think she would be like, you saw Prince Andrew's lawyer come out and say he was part of that class of people settled for that Epstein fund. That is not a class I'd ever want to be a part of. Sometimes in class action cases like the tobacco cases, you could opt into the class, or if your credit card information was stolen, you get an email saying, yes, I want to opt into this class so I get free credit reporting or whatever it may be. You don't want to opt into that Jeffrey Epstein class. You don't want to be associated there, but it seems like some of them were, and I think she may fit into that class. But if she's not, sure. Even if a criminal defendant gets off on the criminal charges, they can still be sued civilly. Absolutely, that's what I'm trying to do. Hey, correct. Aha. All right. Let's see here. So some of these Holmes recordings are public. They've all been called private recordings that the jury asked for private recordings. So I'm not really sure which ones they asked for, but Mimi has seen some of them online. Correct, VSync, but there are extenuating circumstances where the judge would grant a continuance based on the impossibility. So it's not like everybody could get out at the same time. I get what you're saying. You want to do anarchy. We want to have the purge, but probably not going to happen. Oh, Sapphire was like spot on, specific to the, what is it? Lime plus lime and watermelon, even in the right order. Well done. By the way, I've worked in medical devices and you don't want to see how the sausage gets made. That is just about true of everything, don't you think? Thank you, Rye Davis. Thank you, Julia Blair. Thank you, Extended Play. I agree. Thank you, Zor. Thank you, Marlene. Lawrence, we broke down what's happened so far in Maxwell and Holmes. We're still going to talk about Alec Baldwin here in a few minutes. How long have we been going here? 35 minutes? I am not in Florida right now, Sherry. So that's why I have the beanie on. Thank you, Judy. Nope, these think we're talking about Maxwell's trial, who has the connection to Epstein, and Holmes's trial. If they do have a connection, I don't know about it. I'm just talking about these two trials together. Yep, it is an aha. Dennis, we love you down in Australia. Hey, that It does seem to be a lot of Aussies in here, which I love. That's awesome. Raina, do you personally think it was a good or bad choice for Holmes to testify? So this is a really weird one because she went into all of her psychological problems, then didn't call the expert. I do think the jury did want to hear from her, as they do in every case. I probably wouldn't have called her and hoped that it was too complicated of a case and the prosecution just didn't really prove all the specific little nuances to the charges. I would have tried to pick that apart. I probably wouldn't have called her, but I don't know if I would say it was bad. I think it was a tough case. If found guilty, they're not going anywhere. Once somebody's found guilty, they're always a flight risk. Zor, hey, Laura, when would a case not be retried in the case of a mistrial or hung jury? The only time, well, I mean, a couple ways. If the prosecutor felt like they lost the case or it wasn't worth spending the time and resources on again, they could dismiss the charges if they feel like that's just. Or what's more likely, not necessarily in these high profile cases, but in a lot of cases where you get a hung jury, both sides realize, listen, we've got a pretty good case. Maybe it's not a winner, but it's definitely not a loser. So let's see if we can come to some sort of plea deal, either reduce the charges, reduce the punishments that you're offering, and let's see if we can get it done. And sometimes they get resolved that way. So those are the reasons why it might not get retried. So ferocious, what happens if you get called for jury duty, but you didn't get the letter or sent to the wrong address? Nothing really horrible happens as long as it's excusable neglect or just a mistake. You can call in and say, hey, I missed it. They'll put you on another list. But if you continuously and purposefully try to dodge jury duty, then there could be repercussions that come down. You could be held in contempt potentially. Patty Fleck, what happens to the notes the defendants take during trial? Usually we will put them in the defendant's file after the trial. Win or loss, the defendant can throw them away if they want to. They don't go back to the jury or anything like that. 23 and snowing Wisconsin. I'm definitely not in Wisconsin. Arizona, good deal. 26 and snowing in Michigan. Thank you, Lawrence. I don't know, Sapphire. That was a weird one. Why did they call the doctor in the Holmes case? I don't know. Very, very weird. All right, Jonah. A little off topic, but what do you think of Kim Potter's chance of an appeal? It looks like the attorneys set her up for one. And then another question here, could one or more guilty verdicts be appealed? So yeah, they can all be appealed always, and most of these will be appealed. I'm not sure if Kim Potter has a stronger chance at winning the appeal than any other guilty verdict that we've seen recently. I do think that she had a stronger chance at a not guilty verdict than a lot of these other ones that we've seen come back guilty, but it did come back guilty. So obviously that was the answer. But I don't necessarily know that sometimes when you're close to a not guilty verdict and you feel like you've won the trial, but you lose, you actually have a worse chance of an appeal. So new Chris, I actually did, so here's this question. What's the longest you've heard someone sit in jail waiting for trial? I was reading of someone in Illinois that had been in trial for 8 years waiting to go on trial for murder. So I wrote a paper in law school that was actually published after law school in the Florida Criminal Defense, the statewide journal that we published called The Defender. And it talked about some of this. And there are people that have been in prison for 11 years waiting trial. They just sit there and wait. They're low socioeconomic, obviously. They mostly have public defenders, and they just don't have people advocating for them. They slip through the cracks. And again, the courts get clogged, and it's just easy to keep kicking these cases, and they sit there forever, and it's horrible. Now, what's interesting is most of the time, the ones that are there for years and years and years end up in guilty verdicts. Now, why is that? Some people think you sit there for 11 years. How can you possibly have your fair day in court? None of your witnesses are going to be available, but that also could make it harder to prosecute the case. You've just been beaten down and you have no hope left if you've been sitting in prison for that long. And what does a jury think? If I'm accused of murder in 2008 and I'm coming to trial in 2021, very, very strange and different set of circumstances. That's just kind of what I think, but you guys let me know. All right, let's talk real quick about Baldwin, because there's just one thing I want to talk about with Baldwin. So I know some stuff has come out. He's made some videos thanking people for being with him during this awkward and difficult time. But the victim, Helena Hutchins' dad, has come out recently and said he does blame Baldwin partially for the death of his daughter. And he said, I can't understand why he would say stuff like, I didn't pull the trigger. That's impossible. Why did he make this statement or that statement? Why did he delete his tweets? Why is he altering evidence? Stuff like that, right? So where's all this stemming from? Because earlier on, it didn't seem like Hutchins' family was blaming Baldwin. But after his brilliant TV interview, where he tried to convince the world that he was not liable, we've heard from the armor, who has come out and refuted some of his statements, saying that's not true. This is the truth. This is why Baldwin's at fault. We have had law enforcement come and want his phone now and investigate that interview and the statements he made. And now we have the victim's family seemingly turning on Baldwin. Now they're saying, what do you mean you didn't pull the trigger? How else would the gun go off? Why were you even practicing like this when you weren't supposed to pull the trigger in the scene? Why were you practicing like this when nobody else was in there and the cameras weren't running and this was just rehearsal? Why would you pull the hammer back? Why would you do these things? Taking everything he has as points of contention and throwing them back at Baldwin, and he only knows about those points of contention because of that interview. That interview was the worst thing you could do. I hope all of you are learning that, and I don't mean all of you feel this way, but a lot of people hate lawyers that tell their clients to remain silent. But I hope you're learning a little bit why. Because when people just go out and start talking, they say so many things, and they think, even if Baldwin did nothing wrong here, right? Let's just assume he did nothing wrong. He just makes himself look worse with this interview, saying these things, being available to pick apart. Maybe he had no clue what happened. It's totally an accident. The gun went off in his hand, right? But telling people exactly what you're doing with your thumb and everything like that just gives them the opportunity to be like, well, actually, it is his fault because he did this or he did that, as opposed to just keeping his mouth shut. It's just not a good idea. Not a good idea to do that interview for the world to see. All right, any Baldwin questions or any other questions you have, now is the time to get them in the chat. If you enjoyed the video so far, hit the like button for us, because apparently it attracts new viewers to come in here and get their questions answered as well. We just hit 25,000 subscribers. So if you haven't subscribed already, take a second, go subscribe. We will still be here when you get back. Wow. Jukes is watching from Papua New Guinea. That's cool. So Zor, can you talk about the case you are most proud of having worked on? So most of my cases that I'm most proud of are confidential settlements for people that were horribly wronged by someone else or injured by someone else or at a company or by a driver, by a drunk driver. And we've had some cases we've got great results to set them up for life, to where they'll be able to live comfortably even with the life-altering events that have come for them. So just about every case that comes to mind that I'm most proud of are victims that we were able to get set up in the best situation they possibly could without obviously taking away the bad that happened to them. That's what I'm most proud of in doing in my career across the board, is not even some of the most high profile cases or even the biggest verdicts sometimes, or biggest settlements. Sometimes they're smaller settlements, but it's just this person really needed it and they really got screwed because of someone else's recklessness or just horrible decision making. And we were able to go and prove it. And sometimes proving it is just so fun when you find out people lying and can prove that they're lying. So that's what I'm most proud of kind of in my work generally. I don't know if I can put my finger on just one case. Me, us, I rock a bunk bed like a semi-pro. All right. Carrie Adams, there's been lots of videos on this. You can go check out the ones on our page to talk about it a little bit, but I think we're going to find out. I think we're going to have a lot of experts come and testify in that Baldwin trial if it does happen, and we'll find out all the ins and outs. Cheryl, can the interviews Baldwin was giving on television be used at trial? Absolutely. Does the fact that he's under oath matter? No. So they can't necessarily be, it depends on whether or not they are like evidence, but like we talked about before with the FBI notes, absolutely he can be impeached with these all day. They can be used at trial by the lawyers a million different ways. They can be demonstrative aids. They can play them to the jury, especially if he contradicts anything he says in that interview throughout the trial. Now, because they're not under oath, his lawyer can't say Baldwin's not taking the stand in a criminal case. We're just going to play this interview. Can't do that because the prosecutor has to have the opportunity to cross-examine him if a criminal case comes against him. What would Baldwin be charged with if he is charged? It would be some kind of negligent homicide like manslaughter, accidental killing. Assuming they don't come out with some motive that he did intend to kill her. If they can prove some reason that he intended to kill her, then obviously it could be first-degree murder. But I think it's more likely to be some kind of negligent homicide and potentially assault because of the director that also got shot. Linda G, is Sunny Balwani as culpable as Elizabeth Holmes? I don't know. I kind of always, everything I read and listened to in the trial seemed like she was the head of the snake, but we'll see. It seems like he maybe going to trial as well. So on the Kim Potter defense, lethal force for a resisting arrest of a traffic stop seems a little extreme. Can you explain that point a little bit more? So the way they got there, the way the defense lawyers got to lethal force being necessary is because the car that the defendant got in, or I don't know if I should call him the defendant, I guess the victim, but he was getting arrested at the time. He was a suspect or person of interest who turned into a victim, but he resisted arrest by getting into the car, and then some of the police officers' bodies were kind of in the car, around the car. He could have run over their foot, run over them, hit them, taken off while their body was inside the car. That could have caused serious bodily injury or death. Therefore, lethal force was appropriate. That was the defense's argument. Jury didn't buy it. And what I think, and what I said in other videos, is the biggest point is it doesn't seem like Kim Potter herself at the time while it was happening felt like lethal force was necessary, which is why she apparently tried to grab her taser, but accidentally grabbed her gun. Hanoi, watching from Montreal, Canada. So, interestingly enough, me and another lawyer at my firm were interviewed by some Canadian lawyers and the whole Canadian Bar Association. We presented in front of them because their courts are backed up and clogged even worse than ours, and their trials take 4 times as long as our trials. Just a fun fact. So a bunch of questions on, do I think they'll criminally charge Baldwin? I don't know. This is really tough. I mean, I kind of feel like yes. But I don't know. I don't feel strongly about it. Annie, I will. Thanks for joining us. So yeah, it could be. No, I'm not. No, I don't know exactly what he's charged with. I don't know exactly the ins and outs of the case, but normally this video could absolutely be put in as evidence. Normally, yes. People put Facebook pictures and videos and things like that into evidence all the time in cases. I don't know why this would be any different. It's not necessarily coming in just as evidence, boom, and it's not coming in as his statement that can't be cross-examined, but it can come in as evidence. Cat without a hat, why is the only constitutionally honored right in the court the Fifth Amendment? The rest are barely recognized. I disagree with you. You've had a lot of talk about the Second Amendment and Fourth Amendment as well in court cases. Annoy. I mean, I don't think he's going to get convicted of first-degree murder unless they can prove some kind of intent and plan to kill her. Thank you, Catherine. Are all the trial proceedings the same? No, there are tons. We have actually different rule sets. There are criminal rules of procedure and civil rules of procedure. Now, the rules of evidence are the same, but not the rules of procedure. Thank you, humanitarian. Julia Blair, it's crazy. There's a bunch of reasons why we did like an hour and a half presentation on unanswered questions, but the judges don't push them as much. The defense lawyers seem to delay them even more there. They have scheduling issues where the judge won't allow witnesses to be called out of order, which is something we do here. Their discovery is not the same. All their rules are different than kind of how we do it here. There's lots of reasons why. So Grant Uber, when you were a prosecutor, did you feel like you were pressured to get convictions over finding the truth? It was always preached to us to get justice, but it was really, really praised and heralded when you got these convictions. And we're given awards like the Wooden Tie Award for the best jury trial win that I actually got one time while I was at the prosecutor's office, which was cool. But they did celebrate these convictions. I think our prosecutor's office was really good about finding truth over convictions. But there are some cases where it's really hard not to feel that outside pressure, especially police shooting cases on both sides. Like when a policeman gets shot or when a police officer shoots somebody in an unjustified manner, there's a lot of outside pressure where you feel like you have to get those convictions sometimes. So a little bit of both, I guess I would say. I did my best to always, and I also knew I wasn't going to be a career prosecutor, but some of these career prosecutors, I think it's harder for them to get over the pressure of getting convictions and that conviction rate. There was a case I remember I was trying. It was the dumbest case in the world. So when I was very early on, there was a possession of marijuana. Told my supervisor, this is stupid. It shouldn't go to trial. They made me take it to trial. We ended up giving him a withhold of adjudication, court costs and fines, and no probation, and just settling the case basically in the middle of it because it was so dumb. In jury selection, I asked, who here thinks, and this was, 8 years ago, who here thinks marijuana should be legal? Everybody in the venire and the jury pool raised their hand. I was like, oh, great. This should be fun to try to convict on a possession of marijuana. So Zor, calling a witness out of order. So when we're doing a trial, let's say it's a week-long trial. We subpoena all the witnesses. We tell them what days the trial is. We try to give them an estimation like, doctor, we think you're going to be one of the last witnesses in this case. We think you're going to go Wednesday when the plaintiff's case in chief is going to end. Thursday and Friday is going to be the defense's case. So they say, great, we set it up. The doctor's like, I have emergency surgery I have to go to on Wednesday, but I can be there Tuesday to testify. So instead of calling him Wednesday when we were supposed to, we call him Tuesday. Sometimes even we'll call them during the defense when the defense is going, or the defense will call one of their witnesses in our case in chief because they're totally unavailable the rest of the week. So our options are we either continue the trial and it gets kicked 6 months from now, we have to do it all over again, or we just let the defendant call one of their witnesses in the middle of our case in chief. We tell the jury, hey, scheduling issues, everybody understands, everybody's got jobs, things going on in their life. This is a defense witness. They're going to call them, tell you their story, but don't take it as part of the plaintiff's case. That's calling a witness out of order, basically. It's just for scheduling conflicts so we can keep the trial moving. What is your take on all the cop watch audit channels? Some know the law more than others. I'm not sure what you mean. like YouTube channels or Cops, like Cops the show. I'm not sure. I don't know what you mean. Paul Wilson, I think that was denied. I think her testimony came in, but I'm not positive. Now that you say that, I don't remember seeing it. Catherine Merchant, great question. How did you decide to do YouTube, and who do you follow? So it was during the pandemic. I'm a big marketer, get out there, talk to people, networker. I like, connecting with people. I always feel like people want to hire me and trust me to be their lawyer when they know me and we build a relationship versus a billboard or an internet ad where they click it. We get some cases from internet ads and they click it and we happen to show up on Google. They see our page, they like us, they call us. But I always felt like building a connection with people was always better, to network, to help them understand the process. And so that was one of the reasons I started a YouTube channel, is so I could get to know people. They could know me if I was the right lawyer for their case, because I'm not the right lawyer for everybody and for everybody's case. I wanted them to get to know my personality, how I think, how I break things down. I also wanted to help kind of as a resource to the community, answer questions, let everybody feel like they've got a lawyer they can text or comment to or email. My email's always posted. My phone number's on my website, tragoslaw.com. I give that out freely for people to call for legal advice. I don't give legal advice on YouTube, but if they call me or email me privately, I'll give them legal advice. I'll answer their question. I'll connect them with lawyers all across the country. I've connected people with lawyers in Texas, Wisconsin, California, Colorado, Washington, D.C., Maryland, North Carolina, all over from YouTube. So it's been cool to be able to do that, connect them with lawyers, because I know lawyers all over the place, and some people don't know where to start. So if they know me from YouTube, they can email me or call me, and I can at least help them get the ball rolling, know what to look for, what's important, what's not, what's bogus. We broke down some lawyer websites that are just totally bogus and aren't at all what they seem like. So that made me want to do YouTube just as a way to get out there, even during COVID, meet and talk to as many people as we can, still network, still market, things like that. And it's been really fun to do. And then it's just become really interesting and fun. And I can't believe it's growing. Like, I expected to have like 100 subscribers maybe. So that's been awesome and that's cool. Who do I follow? So during the pandemic, when there was no live sports, also I feel like I get better at things that I understand. I'm like, I used to listen to podcasts all the time. I still do. And that's when I first started years ago, was doing a podcast. And so I knew the beats of how a podcast work. I didn't know anything about YouTube. Then I started, when sports went away, live sports went away because of the pandemic. I started watching these golfers like GM Golf. I don't know if any of you guys watch him or know that. Good Golf, No Laying Up, the Foreplay Golf guys, a bunch of golf channels. So that's what kind of got me started into watching YouTube, is just watching these YouTube golfers play matches against each other live at these cool courses. And so that kind of got me into it. Then when we talk about lawyers that I follow, I don't watch a ton of lawyers do these videos. I don't really have time to watch a lot of them, but a lot of them seem like really awesome guys and girls, like the Rakita Law, Full Law Tube, Legal Mindset Joe, Nate, all those guys seem really cool. And I've seen some snippets of their videos. Grueler, I've seen some of his. I really think the power, or the stuff that he puts up there, the exhibits are really cool. Caught a couple of his. Attorney Tom, I've had on my podcast a couple times. He's cool. He does it a little bit different. He's got his own kind of style, which I think is cool, and I like him. And I've sent him a case over in Texas as well from our YouTube connection. He does a lot of shorts. He was big on TikTok before coming over to YouTube. So yeah, it's a lot of people on there that I listen to. If you have anybody you think I should follow or watch, hit me up in there. In my leisure time for fun, I like watching sports and golf and stuff like that. So I watch a lot more of them. I don't watch a ton of the lawyers on YouTube. The insight they provide is probably cool. I just, I am a lawyer, so what I do every day. So it's not as fun for me as to watch probably what a lot of you do. Like, I watched a lot of those gun experts when the Baldwin stuff was happening. And I thought that was cool to watch too. Other people's expertise, I think, is cool. Yeah, Rakita Law, best follow. Yeah, I've seen some of their stuff. Thank you, C. Dupree. The dumpster shooting out of Texas, I've seen some questions in here about the dumpster shooting. I haven't looked into it at all, so I'd have to look into it before Crime Talk, I saw some of his as well. I've seen his. So Ben Weiser, why do lawyers not like to try civil cases against police or city governments? The number one reason, just being upfront and honest and pulling back the veil, is there are statutory limits, at least in Florida, on your fees. They limit the percentage you can charge, and there's sovereign immunity. So sometimes it's 200,000, 250,000, or 300,000 is the most you can get, no matter what, without basically the governor saying no, you can go get more, or showing some kind of huge corruption. But most 99% of cases against sovereigns, which is police or city governments, are capped at the amount you can get as a verdict. They give you a $5 million verdict, they pay you 300 grand, because that's what the cap is. So you do all this work, spend all this money, you can never get it back, and they limit the amount of money you can get. So it's got to be a great case, a slam dunk case that hopefully you can get worked out, because the client usually doesn't end up winning at the end either, because they have so many fees and costs coming out of the verdict that they don't get anything out of it at the end either. So that's number one. Number two, people usually see that as their own tax dollars. So if you're sitting on the jury and I'm saying, give me $5 million, you're thinking, how's the city of Tampa going to pay for this? I live in Tampa. I get taxed in Tampa. Are my taxes going to go up if the city has to pay this verdict? Or, law enforcement or other government officials, usually it's not an even playing ground when you have somebody against them. They're usually more likely to believe the law enforcement officer or city official. So those are just some of the reasons behind it. Trail Runner 925. Do you think just going through the trial process itself and being incarcerated while waiting for trial results in punishment independent of conviction? 100%. Taking the criminal part out of this, and being incarcerated while you wait for trial is huge punishment. But take that part out. The civil cases. Sometimes civil plaintiffs feel like criminal defendants because of how they're put through the ringer throughout this trial process. Sometimes their deposition can be taken multiple times. They look into their past, their criminal history, their prior medical records that have nothing to do with their injuries in this case, and they just get put through the ringer. They look at their prior tax returns, how much money they made, what jobs they had, how many times they've been married, how many kids they've had, whether those kids were out of wedlock. They just go through all sorts of stuff through just about every trial process that it does feel like a punishment sometimes. And that's something we tell clients before we file a lawsuit, that they understand this is not going to be easy. For us, it's what we do every day. For them, it's not going to be easy. It's going to be a big part of their life. It's going to be a stressor in their life, and they have to be ready for it when they make that decision to file, and it is their decision. And we stress that to them before we file every single one of our cases, so that the client knows, don't waste anybody's time. If you're going to say, actually, I don't want to do that, let's just drop the case. We try to go upfront about how serious it is and let the client make that decision, because it does kind of feel like a punishment to go through trial, even though that's your constitutional right. Thank you, Hado. Yeah, everybody posting Rakita Law in here. Watching from South Africa. 4:30 a.m. Thank you, Snake. The trial is concluded, but no verdict yet. Thank you, Bunny. Michael Kennedy. Yes, our website is tragoslaw.com, and all of our contact information is on there. Our email is in the description of the videos, or on our YouTube page. Our phone number's on there. Everything you can on tragoslaw.com is tragoslaw.com. So you can check it out there. Can't the client pay you also? I'm not sure what that means, but yes, client can pay us, obviously. Awesome, Zorse. You've been with us for a while. That's cool. Thank you. Thanks, Charlie. Yeah, we've got a podcast too. Some of them are the same as the YouTube videos. If we're like breaking down a trial, like Elizabeth Holmes, we've posted all those on there as kind of like a podcast series. So you can skip those if you've already heard them on here. But we've done a ton of podcasts from back in the day that I think are really interesting. Brett Warren, I don't do divorces myself, but we work with some lawyers in our state and some other states that specialize in that are board certified in that, whatever it is. So we can talk about the case and I can connect them with somebody that needs it. I do mostly personal injury cases, wrongful death, car accident cases, things like that, premises liability cases. That's mostly what I do. Then I also do criminal defense. But my dad runs our criminal defense practice. So yeah, we do that as well. Yep, VSync. It's very frustrating. Hit by a taxi and got deposed. They try to. I mean, it takes me, an hour to do a depo sometimes of a lay witness. It takes the defense lawyer 5 hours to take the deposition of my client sometimes because they still say, let's start from 1968. Where have you lived everywhere since then? Where have you worked everywhere since? It has nothing to do with the fact that they were hit by a car on their bicycle and had 6 surgeries on their back. But it doesn't matter. They like to go through all that. Thank you, Mike R. Yeah, Annie, who would watch videos about divorces. I try to avoid those at all costs, avoid family law at all costs. But people need it. I get it. And that's why I know some of the best family law lawyers around. The podcast is The Lawyer You Know as well. It used to be called Peter's Proffer, but you can look it up on there as well. It's on our tragoslaw.com page if you want to go check that out. Lee Braddock. First question is your significant other collectible? Are you going to be able to collect that money? Because you're going to spend a lot of money suing them. Yeah, family law is insane. That's good. All right, let's see here. Do you believe that police will be leaving the force, especially in the Twin Cities? I believe America is less safe due to the Potter guilty verdict. There were some other questions about this, like how do I think this is going to affect police and how they use force and things like that. I do think it's going to set a precedent where they're going to be even less likely to use lethal force, and I hope it doesn't result in. I just saw, some body cam video of a police officer getting shot at a traffic stop for a speeding ticket. The guy just pulled out a gun and shot him right in his chest. So that stuff does happen. People don't ever hear about that or see that. The job is so dangerous and scary, and split-second decisions are necessary every day. So I think it's easy for us to slow stuff down on a video and pick them apart and crucify them. But I wouldn't wish the decisions they have to make on my worst enemy. I have some really good friends that are law enforcement officers, and I pray for them every day because it's dangerous out there, and it's getting harder and harder to be a cop. No doubt about that. I hope they don't leave the force, not the good ones, because then what are we going to be left with? If all the good, honest, deep thinking, critical thinking officers leave, then what are we left with? Yeah, I saw that today. John Madden, the video game OG. Brianna, I think what she's saying is we could be going to a point where officers don't have guns, which you may be in favor of. And some people are in favor of, like other countries. If you watch some of I think they're British. I don't want to, I'm not positive, but if you watch some of the TV shows on Netflix of other cop shows and they come in, they don't have guns. Officers don't carry. They have a specific armed unit, but like detectives who are investigating crimes show up at this place and the bad guys there, and the bad guys got a gun and they don't. It's always mind-boggling to me as an American. I'm sure everybody's not American are like, well, all of your cases are mind-boggling to me that everybody's running around with guns shooting people. Look at how horrible it is, and that's just cultural difference. But there are a lot of countries that officers don't even have guns. So I mean, some people think that would be less safe. It seems like you don't. Maybe I don't want to put words in your mouth, Brianna. I know you're here all the time and commenting all the time, and I know you're not shy, so you'll tell us what you think. But I think what the other commenter meant was she feels like that use of force is going to go away, and if the bad guys aren't scared of officers using that force, are they going to be more dangerous? I think that's kind of the concept she's going with. Have I ever seen a bailiff tackle someone? I haven't seen him tackle someone, but I have seen him restrain multiple people. And it's always the victims' families in criminal cases that want to go after the defendant. Thank you, Carrie. All right, about 5 minutes here. Interesting. UK just busted a bunch of people with 3D printed guns. That's interesting. That's interesting. All right. I think we're going to call it here. I appreciate everyone coming. This was so much fun. If you haven't liked the video and you've stuck with us this long, nobody's going to be annoyed at how many times I ask, because nobody watched it this long except for the crew that's still here on the live. So hit the like button. If you haven't subscribed already, please subscribe. We want to hit big numbers next year, and hopefully we can. It's been so fun to do this. I've got a couple trials coming up that I think will be really interesting. Maybe we'll talk about. There are some trials going on in the world. Mark Means disqualified. I'm sure we'll do a video on that. But as always, you guys make this so fun. Appreciate everyone for coming on. Until the next time, we're out.